And at the time that the 14th Amendment was ratified in 1868, there was no history and tradition of protecting abortion rights. To the contrary, all 50 states prohibited it. But when you're talking about parental rights, as we mentioned at the outset, these go all the way back to Blackstone and even before. No one has ever questioned that parents have the ability to direct the raising, the education, and the medical treatment of their child. This shouldn't really be controversial.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. As we've been doing more and more recently, we have a special guest episode, one that I'm really looking forward to. For today's special episode, we're joined by our guest, John Bursch, who's Senior Counsel and Vice President of Appellate Advocacy at Alliance Defending Freedom. I don't really think John needs an introduction, given who our listeners are, but he's a seasoned appellate litigator, has argued 13 U.S. Supreme Court cases, former Solicitor General for the state of Michigan, and like I said, is known to pretty much everyone who will be listening to this. Also have to mention that John is a GCP fellow, so he's a member of our Good Counselor Project fellowship this year, which is a joy and a blessing for our organization. So John, thank you. Thank you for joining the GCP fellowship, and then thank you for being here with us today.
My pleasure. Thank you.
So we wanted to talk about the Foote versus Ludlow case that you're involved with, but I want to back up first and talk more generally about parental rights and where we are with the jurisprudence around this issue, because it's an interesting state of affairs, as we discussed briefly before we hit record. So I guess my first question or line of inquiry I'd love your thoughts on is basically there are two distinct ways of approaching parental rights. You have the kind of religious exercise specifically tied to religious exercise, no parental rights, and then you have a more general sense that there are parental rights, that this is somehow a fundamental right, but it's not written anywhere in the Constitution. So we get different theories of how we should find unenumerated parental rights in the absence of a religious exercise claim. But first of all, I guess the basic question is, why is this not an enumerated right when it seems so fundamental? And my sense has always been that, well, around the time of the founding, there were a specific set of problems, and there weren't really massive government agencies or bodies that were trying to interfere with the raising of children. And so maybe it wasn't top of mind like free speech and freedom of religion and the right to bear arms. But I'm curious if you have any thoughts on why it's not an enumerated right.
I think your gut instinct is a good one, that there just weren't problems with the government interfering with parental rights at that time. Going all the way back to the Blackstone commentaries and probably even earlier, legal scholars had recognized that parents had the right to direct the upbringing and education and healthcare of their children. And generally, the government took a hands-off approach to that. And when you talk about what was concerning the founders at the time that the Bill of Rights was proposed and then passed, that was actually one of the debates about whether they needed a Bill of Rights, because there was a concern that if the people ratified the Bill of Rights, that sometime in the future, the courts would assume that those were the only rights and that there were no other natural rights. And instead, what most people believed at that time is that they were codifying some rights, but certainly not all of the rights. And that's why you had things like the 10th Amendment and other things. We assumed that we were creating a limited national government that generally wouldn't interfere. And so these Bill of Rights were basically, belt strap and suspenders. We're going to make absolutely sure, even though everyone recognizes these are natural rights, the government shouldn't interfere with these, we're going to put them in writing to make sure. But it wasn't anyone's intention that unenumerated rights would not still be recognized by the judicial system as things went forward. And we're just kind of in this unfortunate period that really started in the early 1900s when the government tried to control what parents did with their kids in schools, whether they could even have private schools or homeschooling, instead whether they had to be public school educated. And once they were there, what kind of curricula you could force on parents and children and things like that, which is now matriculated today into these terrible instances where you've got not only DEI and other offensive curriculum, but actually teaching LGBTQ propaganda. And in the case of Foote and similar cases, giving kids the opportunity to socially transition without their parents even knowing about it, much less consenting to that. So we've come a long way from the ratification of the Bill of Rights, but I think that explains the history why the parental right isn't an enumerated right.
Yeah, that makes sense. And as you said, we're in a very different world from the founding era in terms of having to protect parental rights. There a lot of things come to mind. I was a litigator in a children and youth agency. So when you see the rise of these government agencies that are particularly attentive to the way that children are raised, that creates a new set of questions. But like you said, I think it's the schools, the regime of public schools and mandatory education that really makes this a hot issue. So I want to move into this question of religious exercise related parental rights regime versus not. So, from what I understand, and you can give color to this, but we don't have a ton of parental rights jurisprudence from the Supreme Court. We have the Wisconsin v. Yoder case, and then we got a really important decision in Mahmoud v. Taylor, which said, no, Yoder is in fact alive and well. It is not conformed to, a few confined rather to some Amish families. This is a real doctrine, but those parental rights claims are pretty intimately connected to free exercise of religion. Is that right?
That's right. Although there is another strand of cases that recognizes a parental right more broadly separated from religion. But the problem is we haven't really had any parental rights cases up at the US Supreme Court before Mahmoud for more than half a century. And so the doctrine was not developed well. Talking about this whole thing about unenumerated rights, the court didn't really care about unenumerated rights back in the mid 1900s, the 1960s, 70s. Using substantive due process or penumbras or whatever, the court was perfectly happy to recognize all kinds of unenumerated rights, but without the history and tradition anchors that the modern court uses. So Mahmoud was an incredibly important development because it brought some of those old precedents into the modern era, put some meat on those bones, although not as much as we would like. And then it was with the Mirabelli case that the court issued earlier this year on its emergency docket involving one of these secret social transition cases that the court started to tease apart for the first time the difference between parental rights grounded in free exercise and those that were not.
Great. So let's back up a little bit. I know we've covered these in the past, but where did Mahmoud leave the parental rights jurisprudence before, and then we'll talk about Mirabelli and Foote.
Yeah, Mahmoud was only a religious liberty case. The plaintiffs there were all religious adherents. They had free exercise claims. And so the court did not need to get into a non-religion exercised parental right. In fact, that's one of the reasons that we brought the Foote petition is because the parents there are not religious. And we wanted the court to expand the parental right broadly to include non-religious parents because it doesn't make sense that parents who have a religious objection to LGBTQ propaganda and things like that in the schools would have the right to object, but those who have moral and natural law and medical and scientific objections to it would not. It doesn't make any sense. So Mahmoud comes to the court in the context only of these religious claims. And the court says, well, clearly, like you said, bringing Yoder forward, anytime that a school is engaging in some kind of a curriculum that it would have reason to know that parents would object to, it has to give notice to them and an opportunity to opt out. And that's incredibly important because that gives religiously motivated parents the opportunity to have notice and opt out in a broad variety of situations, not just the LGBTQ propaganda, but maybe the teaching of abortion and contraception during the sex ed class. It could come up in a variety of contexts. But one thing that Mahmoud didn't make clear was whether that right extended beyond curriculum. And so that's how you end up with Mirabelli.
Yeah, so last week I interviewed Jeffrey Trissel, who was involved in the Mirabelli case, but Mirabelli is kind of a breakthrough case, especially with these secret transitioning kind of cases that are making their way up. So I guess what happened? First of all, where does Mirabelli leave us, and then we'll talk about why it's not enough, and we'll get into the Foote case.
Yes. So on the plus side, Mirabelli took the parental right and it actually broke it down into religious parents and then non-religious parents. It made clear that Mahmoud was not limited to curricular, because when you're talking about secret social transitions, that's not about books in a classroom or about the type of issues you're going to be talking about in a classroom, any of that. So now all of a sudden, the Mahmoud right, apparently, and we'll get to that, has a broader scope than just curricular things. And that's a huge win for religious parents. But then the 6 justices in the majority in Mirabelli go further, and they analyze the parental right independently for those parents who just have a secular opposition to their kid being socially transitioned. And they say, hey, what we said all those years ago in these parental rights cases, we still mean that today. And if parental rights mean anything, it means being able to direct the medical care of your child. And when you're talking about social transitions, that is a mental health concern that falls squarely within the heartland of that right to direct your medical education.
Yeah.
Not education, but medical care.
Right. Yeah, it's an important push forward. One question I'm curious about, it's a little bit tangential, but I think it's a really interesting thing that was brought forth in the dissent in Mirabelli. I think, was it Justice Kagan who wrote the dissent?
It was.
She expressed some irritation, not just with the majority opinion in Mirabelli, but with the use of the quote unquote shadow docket, that this emergency docket was, I'm paraphrasing, but basically the court already knew what it wanted to do, and it just did it here without going through the proper procedures. But I think it's an interesting, and I'm not a Supreme Court litigator by any stretch of the imagination, but to me, I think it's a good reminder that the Supreme Court is in fact a court. It's not just like a philosophical body that can, sit back and wax poetic or philosophic or whatever when it feels like it, but it does have like a legal job to do as a court. So to me, it makes sense that there are emergencies that come before the court and would be disposed of this way. But I'm curious, do you have any thoughts on what's going on there, or what's behind that kind of jab at the supposed shadow docket?
Yeah, she took 2 jabs, one procedural, one substantive, and I'll try to address those in parts, because the substantive jab that she takes goes right to this issue of unenumerated rights that we've been talking about. But on the emergency docket, which some people derisively call the shadow docket, there's been a lot of ink spilled about the court issuing these emergency orders and whether they're binding on lower courts. And often these emergency orders, because they are emergencies, will simply declare the result. They will lift a stay, vacate an injunction, impose an injunction, whatever, and not have any reasoning. And the court has been criticized for those, because the court has suggested that those types of orders should be followed by lower courts, but yet without any reasoning underlying them, it's really difficult to take an order in one situation and apply it to a completely different set of facts. So I get the criticism there. And the court has tried to remedy that somewhat in the last couple of terms by not issuing one of those peremptory orders every time, but instead granting cert and having expedited briefing and an emergency oral argument, and then deciding the case within a month to 60 days. And that's been an effective way to deal with that problem. But in other instances, you just can't do that. So here, the court didn't just issue this one-liner. It issued a 6-page reasoned opinion. And Justice Kagan said, well, now courts will feel bound by that, even though this is just kind of our preliminary look at it. It hasn't had the benefit of full briefing and argument and the opinion writing process and all that. And the majority, or at least the concurrence, kind of throws up its hands and says, well, before you were complaining because our orders didn't have enough reasoning. Now you're complaining because it has too much. Like, what are we supposed to do here? But where Justice Kagan has a point is that the court has a vehicle, this Foote case that has been pending since at least last December. And rather than take that case and decide it on the merits, they could have had an opinion by the end of June if they wanted to do that, earlier if they wanted to do that. Instead, they did it on an emergency basis. So I can kind of see why she would complain about that there. And it's ironic, as a religious liberty and parental right Supreme Court litigator, that Kagan is actually our biggest cheerleader on this case. Yeah, you should be granting Foote and have oral argument and decide it. We completely agree with that. But I think the majority's point is that you were talking about thousands and thousands of students in California who are subjected to the secret social transition policies. And the risk of that happening to even a single additional child was so great that they couldn't wait, that they needed to do something on an emergency basis. And then they can clean this up in a merits case later. So just quickly on the substantive objection, she says, well, aren't these the same justices who said in Dobbs that there is no substantive due process right to an abortion? You look at Justice Thomas's concurrence. He says that there should not be any unenumerated rights found in the substantive due process doctrine at all. How can they now be finding that a parental right exists? And on its surface, that sounds like a valid criticism, but really it's not. And there's a concurrence that Justice Barrett writes, joined by Kavanaugh and the Chief, and it's really persuasive on this point. She says, look, no one said, other than Justice Thomas, that we should get rid of substantive due process hook, line, and sinker. We're just saying it needs to be tied to history and tradition. And at the time that the 14th Amendment was ratified in 1868, there was no history and tradition of protecting abortion rights. To the contrary, all 50 states prohibited it. But when you're talking about parental rights, as we mentioned at the outset, these go all the way back to Blackstone and even before. No one has ever questioned that parents have the ability to direct the raising, the education, and the medical treatment of their child. This shouldn't really be controversial. And even if you single out Justice Thomas as the one justice who thinks that substantive due process should go, hook, line, and sinker, he would say that you could still recognize unenumerated rights under the Privileges and Immunities Clause using that same history and tradition test, so long as something is deeply rooted in tradition, like parental rights, but not like abortion rights, not like assisted suicide rights and things like that, then we should all be fine with that because the earliest American courts would have recognized that. So I think Justice Kagan has a point, although I can see why the majority did what it did on the procedural objection. I think she's just out in left field on the substantive objection.
Yeah, that makes sense. Good. So I think that kind of lays out the reason why the matter's not settled and why we need a merits case here. So let's talk particularly about Foote v. Ludlow. Before we get into the importance of why this is the case to do it, can you just tell me a little bit about the facts and the background and where this case is?
Yeah, it's a really outrageous set of facts. That the parents were notified by their middle school daughter's teacher that she was having some issues at school, emotional and mental health issues. And so they thanked her profusely for that. They got her into counseling. It was apparent that some gender confusion was one of the issues that she was dealing with. And so they were working that through with the therapist and their daughter. And they specifically gave the school instructions not to interfere in that mental health treatment plan, that they didn't want anyone at school talking to her about gender ideology. Well, the school had a policy, the entire district, of these secret social transitions, so that if a child came to someone and they expressed an interest in becoming another gender, that the school would not only help them do that, but keep it a secret from the parents. And that's exactly what happened. There was a non-binary librarian and also a counselor who were giving her websites to look at, who encouraged her to identify as genderqueer, who encouraged her to use a new name and new pronouns. And then they made sure that everybody in the school was using those. And they sent out correspondence to all the relevant teacher and staff to make clear that this was happening, but that they should not tell the parents. So this is not just without notice. This is in direct contravention of what the parents asked to happen. So this teacher who initially informed them about the mental health issues felt bad about what was happening. And so she violated the policy and told the parents everything that was going on. And the school district immediately fired her. And she's got a wrongful termination cause of action, which is also pending against the school district. So the parents, as you can imagine, as we would be, were absolutely incensed to find out what was happening. And so they went to the middle school principal and he refused to meet with them. His position was basically that his staff knew better what was best for their daughter than they did. So they went to the superintendent and he basically gave the same line at a very public school board meeting. He said that people who opposed the school policy, like these parents did, were bigots and hated transgender people, which is just absolutely ridiculous, preposterous. So they weren't able to get any remedy through the school at all. They were forced to file a lawsuit. The district court threw out their case. The First Circuit Court of Appeals then affirmed that dismissal. And the First Circuit's position was that, one, parental rights basically stop when you decide to send your child to a public school. Your ability to direct education would include where you send them to school, public, private, or homeschool. But after that, then the public school gets to make the calls and the parents don't. Second, even if you did have some parental right at school, it didn't include demanding information from the public school district. That what the school did here was akin, and this was the analogy that they used, to giving a student information about how to become a bricklayer. And if the student becomes a bricklayer, then that's their own choice. The parents don't have anything to do with that. It's not the school's responsibility to inform you about that. Just absolutely ridiculous. And so that's where the First Circuit left off. Well, as you can imagine, these holdings created conflicts with other circuits. And so we used that as an opportunity to ask the Supreme Court to weigh in on this once and for all. As you may be aware, that aside from Mirabelli, there have been roughly 2 to 3 dozen of these lawsuits pending in federal courts across the country. And the Supreme Court has denied cert in several of them, either because they weren't ripe yet, because it wasn't clear that there was a policy, because there was some other vehicle defect. And we thought that Foote was going to be the ideal case for them to issue a merits ruling on this because it didn't have any of those problems. The policy is clear. It was violated in the most egregious way. And it's now time. There's too many kids who are being hurt. The court can't look away any longer.
It's a horrible story. I mean, it's a great set of facts to bring this case up, like you said, particularly because this wasn't just a secret gender transition, but the parents were already in the process of a mental health plan that was basically being ignored. That makes it a really strong case.
The non-binary librarian even suggested to the daughter that her parents didn't have her best interests in mind with the therapist that they had retained. So she was even undermining the parents' choice of therapist.
Yeah, there are so many issues. One of the places where I become discouraged about the state of education and clear thinking in our culture is when you have a basic, like what you said, an argument that, teaching a girl how to become a bricklayer or teaching a kid how to become a boy, when we equate these as the same thing, pretty horrifying state of affairs. But
it reminds me of a Third Circuit decision a couple of years ago in a transgender bathroom context where the school was allowing boys in the girls' showers and locker rooms and vice versa. And when the girls complained, the Third Circuit said, well, they shouldn't be complaining because a boy who identifies as a girl, which they call a trans girl, is a girl. And so you can't have any more reason to be uncomfortable around him in the locker room when everybody's naked than you would if it was a biological girl, because they're the same thing.
Yeah, right. And the answer is that they are not the same thing. It is really that simple.
Any 3-year-old would be able to tell you that.
That's right. Wow. So you wrote a letter to the Supreme Court after the Mirabelli case, I guess kind of reiterating that this should be a case that the Supreme Court takes up. So obviously it's too late for this term. Is there any sense of the timeline or how likely? I know it's dangerous to speculate on what the Supreme Court will do, but does this seem like a case the court is likely to take up?
Well, it's still a bit of a black hole. The letter that we submitted made the point that on remand back in the Ninth Circuit, the California Attorney General is telling the Ninth Circuit judges that the Mirabelli decision, because it was on the emergency docket, is of no binding authority on them whatsoever, that they can consider it as persuasive authority, but they can do whatever they want, which makes clear why you need to have a merits decision. In that respect, Justice Kagan's dissent is exactly right in Mirabelli. So here's the weird thing about what the court is doing. Usually the court will consider a case at conference a handful of times and then either grant or deny it. The vast majority of cases get denied after a single conference, but if they're strongly considering one, there may be a couple of conferences. Well, Foote has been considered 12 times now, and they still haven't made a decision. It's not a record, but we're kind of moving into that, 1/1000th of 1% category that have had that many conferences. What makes it even stranger is that when we filed the petition, we linked it with another one of these secret transition cases called Littlejohn. And in Littlejohn, the 11th Circuit recognized that the parents had some rights, but they applied a very difficult standard for the parents to satisfy, that school officials' behavior had to shock the conscience, not just that you have a parental right and the presumption is that you can't interfere with that. And so we thought it would be perfect to take both of the cases together, resolve the standard, and then resolve the merits. And you clean it all up in one shot. So what's odd is that Littlejohn makes it to the court for conference at the beginning of January. Still plenty of time for them to grant both cases, hear them this term, make a decision by June. And for whatever reason, Littlejohn got rescheduled to another conference. And any justice can ask for a reschedule. They don't need to give a reason. They just need to say, I don't want to consider that one this week. And then it gets bumped. Well, then it got rescheduled again and again and again and again. And now it's been rescheduled, I think 10 times, give or take. And it has never been conferenced. So perhaps the reason why we're waiting in Foote is because some of the justices want to consider both cases together. And at least one justice is preventing that from happening by continually rescheduling Littlejohn as is their prerogative. And it's not clear why any of that is happening. But if the court was simply going to deny Foote, and there might be a dissent or a concurrence in that or something, it most likely would have come out by now. So it appears that they're still waiting to get Littlejohn so that the two are joined at the hip, and then they can make a final decision about both of them. We do think that it's an ideal case to decide the issue. And even though they can't hear it this term, getting it in process so it can be heard early next term is still to everybody's advantage. There's one group that, by its count, says more than 6,000 public school districts across the country have these secret social transition policies. And it's time for the court to decide it definitively in a merits opinion.
Yeah, and from my perspective, the Foote case is a really, really compelling set of facts to do it. So I hope that this is the case that will, break through on the 13th or 14th conference and actually have cert granted. I know we talked. Please.
I just said we hope so too.
Right.
It would be hard to find a better one. There was another one of these secret transition cases that also had a petition filed. It was called Levine, I think, Lavigne. And it was one that had some vehicle problems, and they turned that one down immediately. It only went to one conference, and then there was a denial. So clearly there's somebody who's interested in Foote, likely a couple of somebodies, and it's a matter of figuring out what they want to do with it.
Right. So I know we talked a little bit about the various constitutional theories for the unenumerated parental right. So assuming that cert is granted in Foote, what's the basic constitutional theory? Like how do we get there in the absence of a religious exercise claim? What's the most likely avenue to a parental rights ruling in a case like this?
Well, interestingly, in the lower courts, the school district on the other side did not challenge the existence of the parental right. So that hasn't been litigated at any stage of the proceeding. We're all going ahead on the assumption that the Supreme Court's precedents are still good law, and Mahmoud and Mirabelli are just the latest examples of that. So it's not clear that we're going to have that question decided in order for the case to be resolved. But if I was pressed at oral argument, I would be hard pressed to do better than what they did in the concurrence in Mirabelli to say you've got two choices. Everyone acknowledges that parental rights have been around since before the founding of the Republic. And there's nothing in the Constitution itself that suggests that parental rights were excluded when the Constitution was ratified or when any of the rights in the Bill of Rights were adopted. So we have to assume there's a parental right. And as long as it's rooted in history and tradition, it doesn't make any difference to us whether it's substantive due process or whether it's privileges and immunities, you get to the same place. The important thing is it has to be rooted in history and tradition, because without those deep roots, then courts are left free, as they did in Dobbs and as the Supreme Court was asked to do in the context of physician-assisted suicide, to just make up whatever rights they wanted.
Yeah. I won't hold you to, if you don't want to answer this in any detail, that's fine. But I think it's a very curious question about the substantive due process issue, because in like the Federalist Society, nerdy, conservative, intellectual movement circles, there's a very common question. And to me, that's just substantive rights are not found in due process because process is about process, which is actually like the opposite of substance. But the reality is we have a very long line of finding unenumerated fundamental rights in the substantive due process doctrine. Do you see a way where we can actually unwind these, move them into privileges and immunity? I know we don't have 5 votes, certainly on the Supreme Court for that at the moment, but if we did, how do you think it's more likely that we'll just continue to hone history and tradition under substantive due process? Or do you think that this is actually something within reach in the future, that it finds itself in another clause of the Constitution?
Yeah, I think it's possible, but probably not in the near future, because they would have to unwind so many decisions. And obviously the big one that I argued on behalf of the Catholic Church's teachings about marriage was Obergefell. And if you wanted to unwind Obergefell, you could easily do that by just eliminating the substantive due process doctrine, then looking under privileges and immunities. Was there a long history of recognizing that right? No, certainly not. It wasn't even something that was talked about until very late in the 1900s and became a thing in the 1980s, 1990s. But the court is reluctant to overturn precedent when it's going to adversely affect their political capital. The reason why the court can undo something like Roe and Casey in a decision like Dobbs is because we had a 50-year movement led by the Catholic Church of pro-life advocacy, everything from March for Life, Students for Life, Right to Life at the federal level and at every state level, 40 Days for Life, Live Action, just goes on and on and on and on. And so it created a culture where there were enough people who supported the pro-life position that it was politically palatable for the court to do something about that. The numbers show that support for same-sex marriage has started to fall in the last year or two, but not anywhere yet near the point where it would be required for the court to feel it had the political liberty to overturn something like Obergefell. And now there's more efforts to try to create that cultural groundswell, and maybe that'll change in the future. But as long as you have that kind of political barrier, it would be very difficult to just rip out substantive due process, hook, line, and sinker, even if that makes sense. And even past Obergefell, you've got cases like Griswold and others addressing contraception. And that would be an even more controversial topic today, even though the Catholic Church wouldn't think that was controversial. So I don't think there's any realistic opportunity in the short to midterm of the court walking away from substantive due process. I think it would take a lot of cultural work for that to happen.
Yeah, I think that's probably the case. I can mention this because she's a nonprofit leader, but I don't know if you're familiar with Katie Faust, who has the Them Before Us campaign.
Yes.
And she
yes,
recently...
So she's one of the bright lights in the same-sex marriage world right now. Really the first concentrated effort to start to win public support back to our side, that marriage is only between one man and one woman. And I hope that's one of many efforts that takes place over the next 5, 10, 15 years, because that's the kind of effort that we're going to need in order to restore the meaning of marriage.
Yeah, she just recently launched this Greater Than campaign, which is particularly to shed light on the Obergefell situation and where this has gotten us. And yeah, you're right. I mean, the Dobbs was possible because of 49 years of consistent advocacy and pressure and cultural movement. And it may take decades to do the same thing, but I'm going to clip this and send it to Katie.
God's got a plan for all that. And, it's hard to know today what that plan is for the marriage movement. But if you think back to the abortion movement, you might reasonably ask yourself, well, how could God ever allow something like Roe versus Wade to happen? It's a tragedy from every possible angle that you could look at it. However, if there hadn't been a Roe and a galvanizing moment in the pro-life movement in the United States, we would probably look like England, which didn't have a Roe moment, but just kind of slid like the boiling frog into an abortion culture where a counter pro-life culture never developed. And so you've got abortion on demand everywhere in England today, virtually no pro-life apostolates. You've got some prayer warriors at clinics. They're all being arrested now. But there's no pro-life movement and no chance whatsoever of having any pro-life territory within that country. And it was only because we had this galvanizing moment and then the political and religious movement that followed that we have such a commitment to pro-life ethics in the United States. And we have 6 states where there's no abortions allowed except to preserve the life of the mother or in cases of severe health impairment. That wouldn't exist if we had followed the path that the UK did. So, even in that, you can see a long-term plan for the salvation of society. And perhaps we're going to require the same thing with marriage. It's just going to take a lot of hard work, boots on the ground.
Yeah, no, I think that's well taken. That's right. One other question I have on the world of particularly Mirabelli, but these secret transition cases that I think hasn't gotten much attention, but did get some in Mirabelli. And an interesting twist is the role of teachers caught in the crossfire of these insane policies, right? The posture of Mirabelli I thought was really interesting because the lawyers there from Thomas More Society and Jeffrey Trissel, they liked this case because there were teachers who objected to basically being forced to speak a certain way, and that they thought that was a unique vehicle to try to keep some of the standing issues that are often faced with parent plaintiffs in these cases. And it was interesting because then in the per curiam from the court, the parents were focused on, and the teachers kind of fell away in the Mirabelli decision. But I think that's an important. It's separate from parental rights, but I think there's still something there that these regimes are essentially telling teachers to lie and to conceal things from parents. Is that something you expect to see any more litigation on, or do you think the focus will remain mostly on the parental side?
Oh, no, I think the free speech aspect of the teacher's claim will definitely continue. We've had a number of those cases and have had quite a few successes. The Virginia Supreme Court said that a public school teacher could not be compelled to speak a lie by using pronouns and legal names that were not reflective of the child's sex. So that was a big win. In the Sixth Circuit Court of Appeals, we had a public university professor, and they said the same thing. It violated his free speech and free exercise rights to compel him to use preferred pronouns that he thought were a lie and harmful to students. And then in the Seventh Circuit, it was a slightly different scenario where he didn't want to use the preferred pronouns, and he asked for a religious accommodation under Title VII. And the Seventh Circuit said that he had stated a plausible claim for that and that it had to go to trial. And the school district ended up settling and paying the teacher $600,000 rather than go to a trial over the question of preferred pronouns. And so I think you'll see more of these cases coming up. They're happening in the schools and colleges, universities especially, but also in government employment, sometimes in private employment. And that's where the Title VII religious accommodation principle kicks in. But we're a long way from being finished litigating those cases. And at some point, the Supreme Court will eventually have to step in on that.
Right. Great. Well, I want to be respectful of your time. Any parting thoughts on the importance of this parental rights issue, where you think it's going beyond the Foote case, what we should be looking at in the months and years to come on this issue?
Well, I think really starting with COVID and its aftermath, parents realize that they have a responsibility, a duty to make sure that what's happening in their child's education and development is something that they pay close attention to, and that they push back on some of these ideologies that are corrupting our youth. And so for anybody who's listening to this, who has a child in the public schools, who lives in a public school district where these types of policies are being implemented, you need to be paying attention and going to school board meetings and speaking out. Now that you have Mirabelli, it would be very difficult for any school in good faith to continue having a secret transition policy. And so people, if they hear about one, they should be asking the board to repeal that. But even aside from that, you can go back to the Biden administration, and he had proposed those terrible Title IX regulations that required schools to treat boys as girls if they profess to be girls, and so on and so forth. And even after the Supreme Court put a stay on those, school districts continued to implement them. And we need people to be paying attention to that and to go to the school board meetings and say, why on earth would you implement a policy that the Supreme Court has said violates the law? It doesn't make any sense. So we need to be watchdogs for that. And really, as parents, you can't just be watchdogs for the kids in the public schools. It has to be in the private schools too, whether they're secular, religious, or even Catholic, because some of these ideologies are even making their way into Catholic schools that aren't carefully policing themselves. And it's so harmful to kids that we just need to be super careful about it. If you think about the child who has gender dysphoria, not just a social contagion, but they actually have the mental health diagnosis, over 90% of them, if they were just left alone, would naturally get comfortable with their body and realign their mind with their natural sex. But if you affirm them with pronouns and name change, letting them wear the opposite sex clothing, sending them to the opposite sex showers and locker rooms and the opposite sports team and all those things, 97% of them will end up continuing in their dysphoria. And that almost always leads to puberty blockers, cross-sex hormones, and surgeries, which make those kids lifelong patients with well-documented medical problems that will last the rest of their lives. So this isn't just a matter of competing ideologies. This isn't just a matter of being polite and using pronouns. This goes to the very essence of what it means to have a child grow up to be the best possible version of themselves and to be fruitful and flourish. And so whether you're a lawyer or a non-lawyer, you need to be paying attention to this issue and making sure that in your local community, your kids, your neighbors' kids, the community's kids are protected.
Great. Well, that's a great place to end. Thank you so much, John. I'm really happy to have you here joining us this morning and helping our listeners dive into these parental rights issues. Parental rights, both attached to religious exercise and not, is one of the most commonly covered topics in our religious liberty work and our podcast. So thank you for being here.
My pleasure.
Great. And to our listeners, thank you for joining us. And if you want to hear more from John, as I certainly do, you still have a couple days to register by the time this airs. Our Napa Legal Lawyers Conference will be on April 23rd at Catholic University of America in DC. You still have a little bit of time to register. John will be on one of our esteemed panels. So John, I'm looking forward to seeing you there in just a couple of weeks at the time of recording. So with that, thank you to all of you for joining us on this special episode of the Napa Legal Podcast. As always, if you enjoy the content we're putting out, we appreciate it if you like the episode, subscribe to our channel on YouTube or Spotify or wherever you happen to be listening from. And we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and particularly the work of faith-based nonprofit organizations. So we'll talk to you next week. Thank you so much for joining us, and God bless you all.